the panel, the discussion, an objective and impartial view of the issues of interest to you. Nationbeat is on now.
Hello and a warm welcome to Nationbeat. I am Claudia Monlouis. In today's edition, we're looking at miscarriages of justice in the Caribbean. Are they a risk or largely imagined? With the 9th annual Caribbean Medical, Legal and Forensic Symposium approaching, experts will explore how forensic science and legal processes work together to prevent wrongful convictions and ensure justice, not only here, but in the wider region. My guests are, commencing from my immediate right, Deputy Director, St. Lucia Forensic Science Laboratory, and Quality Manager, DNA Analyst, Mrs. Joy Quinlan.
Good afternoon.
We have the well-known Dr. Stephen King, pathologist, and also we're joined by Dr. LaShawn Christian, Head of Pediatrics, Department of MHMC, so you'll break that down for us. And I think you have a specialization which extends to child sexual and physical abuse. So we are here to have a very engaging discussion. Of course, the members of our audience may not always be familiar with the terms, so I know that you're professionals who will break it down so that everybody can appreciate the significance of this topic, because it is one which I think impacts just about on every one of us in some way or the other. So I will begin by zooming in on the lab, Mrs. Quinlan.
No problem.
Can you give us an update on some of the recent accomplishments or milestones of the St. Lucia Forensic Lab?
Okay, so the St. Lucia Forensic Lab has, in 2022, was able to become accredited, which means that there is a body, an external body, who comes into the laboratory and audits the lab's processes and assesses whether the lab is meeting a certain standard, an international standard, which is for everybody's, just for them to understand, it's ISO 17025 2017. It is a management standard that enables the lab to do the processes for forensic laboratories and other laboratories so that they can get the results in a very consistent manner and in a manner that the public and professionals such as the doctors and lawyers can feel confident in. We have also been looked at as a center of excellence by the US departments, and we're looking and working, it's been a vision of ours for quite a few years, to be a recognized center of excellence.
Okay. Congrats on all of those wonderful achievements. So we can assure the public that the lab is certified, we're up to the standard.
We are following international standards for forensic processes, and we do DNA analysis, we do drug chemistry, as well as serial number restoration. So all of the processes that we are accredited for, we follow international standards, so that we are, let me put it this way, if we were to send out evidence to another lab, an international lab, our lab's results and the processes that we do would be comparative to an international lab.
Understood, understood. And very commendable. What does the typical workload of the lab look like though? And how is the team managing the demands of forensic investigations in St. Lucia?
So our workload can be a lot because we have 6 technical staff members. And for 6 technical staff members, it means that all of us are wearing different hats. Everybody has something else to do. For example, I'm the deputy director of the lab, but I am also the lab's quality manager and a DNA analyst, which means that one of the things that I think would be recommended is that the lab gets more staffing, technical staff, so that we can produce results in a more efficient manner for the public and for the justice system as a whole.
Okay, very well. Appreciate the context. And now we're opening the discussion to the miscarriages of justice. Is it real or imagined? And of course, I think we can all weigh in on this. What is our perception of this? And in terms of the theme for the upcoming conference, so it's also an opportunity to highlight some of the talking points, which is and presentations which will emerge out of the medical legal conference next month.
Okay. So the question, I guess, the theme asks the question whether it is real or imagined. I think it is very real. Dr. King, what do you think?
I think so.
Yeah.
Yes. I mean, I've been in this life for a while now and seen a lot. And the thing about, first of all, to put it, Claudia, justice is so important for a civilized society and for victims and indeed for accused. We must bring truth to court. The truth, or the very closest thing to the truth that we can get, we must bring it with evidence. And that process is not a simple process. So there is no doubt in my mind that there has been miscarriages. People who are guilty have gone free, and people who are innocent have been incarcerated. And that has happened. It happens everywhere, and for sure it has happened here. To give you just an idea as to in the forensic pathology line, how it is, we try to bring truth and where some errors can occur. Let me just run you through a death investigation for a minute.
Sure.
A report comes in that somebody is dead. Police are mobilized to secure evidence, secure the scene, to secure evidence. Immediately, you can understand there's a time problem right here. Is there contamination of that scene? So it starts right there. Then the professional management of that scene and the collection of evidence. Do we have trained officers who are able? Is there a proper team that is mobilized, a multidisciplinary team that is mobilized to manage a particular scene? Then the transport of that body to the mortuary, a secure facility, is that done in the manner it should be? Is the facility secure? Are the refrigerators secure to maintain integrity of that body? And then, as a pathologist, we come to examine what is our training. Are we forensically trained or not? Claudia, I started doing postmortems when I was a district medical officer back in 1982, right? And I came back in '89 as an anatomical pathologist with some exposure to forensics, but not a fully trained forensic pathologist. And I was doing postmortems. I was doing postmortems for years. But the standards have evolved. And now, to really do a proper forensic postmortem for a forensic pathologist, somebody properly certified in forensics, is important. Even the management of the postmortem is crucial. How do we collect evidence? How would we take pictures to document injuries? Do we have professionals that can manage that? And then we go into how long does it take us to get a report? What types of analyses can we? Can we get toxicology analysis? Can we get proper DNA analysis? Have we collected the right samples? And then it comes time to go to court. And are we presenting the evidence in court in a manner that is appropriate, that the truth comes out in court? So I say all that to point out to people who are listening or viewing us that you can see there are multiple areas where truth can be contaminated. And therefore, the final outcome might not be as just, and therefore it could be a miscarriage. And my interpretation might be wrong of a cause of death. I may not have collected the right sample. I may have been given false information when I'm making my interpretations, because when we make postmortem examinations, we also have information that helps us to make our decisions as to what has transpired. So miscarriages do happen.
Can you reiterate what could lead to exactly that definition of a miscarriage of justice, just to clarify what it is, because it is not every matter that would not be successful through the courts, for example, that would be deemed to have been a miscarriage of justice.
Well, in my mind, a miscarriage of justice is when the court is given information and evidence that does not allow it to get to the right verdict. That's what I think is a miscarriage. So a lot, and what I was talking about was the presentation or the gathering and presentation of forensic evidence in a death. And I just tried to make the point that what comes to court may not be enough to get somebody convicted, somebody who's guilty convicted, or it may be that the wrong interpretation is given and somebody who's innocent gets convicted. So, I mean, and there have been examples of that internationally, well documented. Indeed, we were talking about a pediatric child, pediatric forensic pathologist in Toronto, who was found to have been involved in miscarriage of justice, which caused the entire forensic system in Toronto to be revised.
For years. But one of the things I want to, Dr. King brought up, and I think we need to recognize, is that everything is in a continuum. So a lot of the time we think of each of the departments working alone. But just based on your description, Dr. King, you can see that everyone feeds the other. So from the start of the collection of evidence, and one of the things I'd like to point out that we see a lot in St. Lucia, so we see a scene, and police have been called and they have not gotten to the scene. But what do we see? We see cameras pulled out. We see persons on the scene, probably touching the bodies, moving things, and that in itself can affect the interpretation of a crime scene investigator looking at the scene, documenting the scene, which then now filters down how they collect the evidence and all the way to pathology, to the forensic lab, to the court. So it's important that the public understands that they too are part of this, because most of the time we see something happen, and yes, I guess some of us want to help, but a lot of the time it's not just helping, it's being cognizant of how we can impact a scene also. So I just wanted to bring that up.
Dr. Christian, I know you have your lived experiences as well as your professional interactions, and so I would like you to weigh in on how you perceive the theme of our discussion here today, and of course that extends to the conference, which is coming up.
Right, so even though I'm a pediatrician by profession, at the beginning I was a medical doctor, a general practitioner. And when you graduate from medical school, whether you would have done 5 years or 7 years, depending on the country that you study, you're literally walking into a profession that is held in high esteem, but you have the knowledge in your head. So now you're touching patients, so you have to bring the knowledge to your clinical acumen. Now when you see a patient in front of you, you have to be able to paint that picture for the judge in terms of what you were seeing on the night of, when the attack, for instance, when it happened. So for you to say there was a chop wound to the side, a lot of time that could be interpreted many ways. So rather than to use that term, you have to use medical terms such as a laceration, describe how long it was, describe if it was clean or ragged, or if there was a bruise. You speak about it in the medical term. However, when it's time for the medical report, you have to present it to the court in such a way that the judge and the jury can understand, because you want to avoid any form of any confusion that may result in a miscarriage of judgment of the judgment, right? In addition to that, sometimes the doctors are called to the stand to basically defend the testimony that they would have given. Sometimes they are called as expert witness to see if a medical report that was submitted would actually is in keeping with what is being presented to the court currently. And so if it is not, then there's a role for confusion. You do not want a subject or a victim to feel as if the medical system failed me at the time of presenting to the court, for instance, like we were just discussing, and I will use the term hymen because we all know what that is. A lot of times persons will say, but if the hymen is intact, then it didn't happen. And we as a physician have to clarify the many, the challenges and the sensitivities around what an intact hymen mean, so that the court can understand, so that the victim doesn't feel as if, well, no one believed in the first place. So that is how the role of the physician comes in. You have to be clear, you have to present it in lay term, you have to make sure it's accurate, presenting the report in a timely manner, making sure the chain of custody is respected and that you're doing it in the right way. You do not want to have important information laying on the table and then it reaches to the forensic lab weeks later by an unknown bearer. It has to be given to the, for instance, whether it's the victim protection team or to the police officer, and then there is a chain of command to follow.
What are the safeguards that all of the parties involved in a matter from its point of investigation can undertake? I know that there are times when the public do encroach, as Mrs. Quinlan highlighted, but each professional, what can you share your best practices as regards reducing a possible outcome of a miscarriage of justice? And hopefully, Dr. King, you can weigh in on training, the aspect of training as well.
As you're talking, three things were coming to my mind. One is training, as you said. So one of the things we have to do is make sure that everybody in the multidisciplinary team is properly trained and understands the whole process of forensic science and forensic medicine and forensic pathology, depending on the role that they're playing. So that's from police officers to doctors to everybody.
Judges, lawyers.
Judge everybody. The second thing, I think, is standards. Now, there are standards for everything, and we need to apply these standards. So that, for instance, for a postmortem, to conduct a postmortem, there are standards that we should apply when we are doing a postmortem. There are standards for how we do it, and there are standards for how we report. So these must be followed. And then probably the most important thing that I have found in my experience is communication. So how I used to do my work, because I don't do a lot of that forensic work anymore, but how I used to do my work is create a safe space so everybody can speak and everybody can say, hey doc, what about this? Did you check that? Did you think about this? Bring in the forensic scientist. Let us turn off the lights, put on the special light to see for certain, you know what I mean? Things that I may not initiate of my own, from my own brain, but I have a team, a multidisciplinary team around me that makes sure that we do everything. So I think these are the three things: training, standards, and communication.
All right, so let me jump in here.
Sure.
So all of that goes under quality. Okay? Now, I'm an advocate for quality. I love quality management. And everything that Dr. King just brought up is part of a quality management system. And one of the things I would like to advocate for is a quality management system that spans throughout the justice system. So right now, the laboratory has a quality management system. But one of the things we've found is because we have a quality management system, we are now highlighting all of the faults of the other parts or the other departments. So we're now seeing if, boy, that wasn't collected well.
How well are they taking it?
Not very well. Right, and that's the thing. But again, our culture also does not really help us, because again, what quality does is not to put blame on anybody, but rather help us find causes or reasons why something has gone wrong and be able to solve it or find, good ways of solving it. One of the things that Dr. King spoke about is standards, and it is literally let's just to put it in layman's terms, a ruler so that we can measure where we're at. Are we collecting all of the evidence in the way, in the best practice? Are we storing them in the best practices? Because again, when we don't do that, what happens is the lab will get results that are not very probative in court. So results that are not that doesn't help the courts, the lawyer, the defense lawyers, nor the prosecution, doesn't help anybody. And then, of course, now what will be said is, oh, the lab couldn't find it. But we have to recognize, was it done properly? Was it collected? Was it brought to the lab in a state that the lab could find evidence if it was there? Then in terms of your pathology and with your medical examinations, a lot of the time what we found is that we expected doctors to know certain things. And then we're realizing, oh, the training, so forensic training is not built into the doctor's syllabus or their curriculum. And so that we expect doctors to be able to do certain things, and then we find out, oh, you can't do that. So another thing something else that the forensic lab has undertaken is sexual assault examiner training. So to explain to doctors and lawyers as well as judges how the best practices for collecting sexual assault evidence, and also how it should be stored, how it is used in the laboratory, so that we can bring truth to the court. So all of those things fall under the umbrella of quality, and if all of the departments were to think in quality terms, I think we would definitely do better for the criminal justice system.
Claudia, I just want to add one thing is on my head there. In the face of justice and the court, every professional must have humility. Mm-hmm. There's no room for ego and pride. Amen. And what you find sometimes is your first opinion is not the right one. And other information comes in, and then you suddenly say, I was wrong. Mm-hmm. You have to be prepared as a professional to say why you want to change what you first thought, so that the truth can be brought to the court and justice can be done. It's too important for us to allow pride to get in our way. And as human beings, I can tell you, especially as professionals, our egos sometimes get in the way.
Yeah, that's quite true. I would like to go back to Dr. Christian. You deal with children.
Yes, sir.
And also it brings to my mind the question of communication. Mm-hmm. Dr. King cited communication. Mm-hmm. What are the emerging trends in the justice system as regards to children who may not, be equipped, naturally not equipped to explain what they have experienced, and by extension, persons with disabilities that would impede their ability to express themselves, or perhaps they are hearing impaired, etc. Do those matters normally result in a miscarriage of justice?
Well, often once the doctor sees the subject or the patient and the medical report is generated, if it is very clear, then not all the time you may find that a physician is called to give any additional evidence in court. However, if it is not clear, or if there's something that the judge would like in terms of the doctor's experience, then they'll be called to give testimony. We are seeing quite a few cases, and as traumatic as it may be, we still try to make sure that we are objective in terms of the documentation, so that it is there's no missing information. We do know that, for instance, the children who are nonverbal, especially like the toddlers who may be limited in their expression, or even those who are much older, but they have intellectual basic thinking in terms of a toddler, then at times you have to look at the body language, you have to look at the non-verbal communication, the gestures, for you to then paint this picture, because when it goes to court, they may not be able to give testimony in terms of what happened. And you're trying to avoid a situation where if a case is called like 6-7 years later, and you have that 3-year-old who is now 10 years old, clearly she's not going to remember what would have happened 7 years before, and you don't want to have a miscarriage based on the fact that she has bits and pieces in terms of the memory, in terms of what happened that unfaithful that night when the incident occurred. So I'm hoping that, well, I'm not quite experienced in terms of the court proceedings, but I'm hoping that there's some consideration for those children, or those older children who may not be as verbal to express themselves in the court. Dr. King, you can give some more light on that?
Only because of my association with...
Dr. King, I was just about to compliment you that you can speak on almost anything.
No, not at all. So I know that, for instance, there's video link for children, so they don't have to be intimidated by the court. They can be in a very comfortable setting, and the court will accept the video link. there's often a social worker who is with has been with the child, so that the child feels, again, safe, supported, and comfortable. Now, the social worker is not there to coach the child on the evidence. The social worker is there to support the child, to give the best evidence that the child can give. So that is what is in place in our courts, from what I know.
Okay,
Thank
thank you.
I think too, what we sometimes forget is the other aspect of it. So, for example, a child who is 3 years old, even if a doctor saw this child, medical doctor saw this child, but we also have psychologists. We also have people who can speak to how victims like that would react. And I think it's important for us to look at that data, to be able to discuss it with the courts, so that they can make decisions, or evidence-based decisions. Even we're talking about persons who have some sort of, they're not able to speak, or hair, some sort of disability. However, there are instances with people who are not normal, right? And for example, in a sexual assault case, you may find that that survivor is very stoic, but we expect them to be crying and distraught. And for example, a police officer might say, yeah, that person lied. But then when you look at the psychology, and you bring in a professional that can speak to that, you may find that that is actually a very normal reaction. And so it should not be interpreted as, not being able to believe this person. So I think we need to tap into all, like you were saying, Dr. King, it's multidisciplinary. Yeah. Tap into all of them, all of the different professions that we have, so that we can give a proper picture of what may or may not have happened.
It could even be like a selective amnesia, where even someone who's talking and verbal, because of the emotional trauma, you're unable to remember what happened in that particular point in time.
Yeah.
I think the public knows that. Blackout, people never say why they can't remember, they black out over that when it's a very traumatic event.
Yeah.
Yes, absolutely.
It can happen to any of us.
Absolutely. We're almost at a point of a break. At the break, we are going to bring in Attorney at Law, Mr. Alberton Richilo, to weigh in on this very, it's actually quite a fiery topic. I don't know how much of the fire I should hold back on until Mr. Alberton gets in the chair. But so far, the discussion has been very enlightening, and I wonder if you can point out very gently, of course, because we are here to get better, some of the systemic gaps. I know, for example, the fast tracking of cases is desirable from all parties involved. We'll hold that thought until after the break, but of course we could get our ideas tuning on that.
Fisherfolk in St. Lucia are facing many negative effects of climate change.
La vie pêche est difficile parce que pour ça aller plus fond, ça nous peut acheter plus fuel pour faire journée là, mais nous pour dépenser plus l'argent gasoline. En raison ça la vie pêche est difficile.
Parti là c'est bay qui peut affecter nous la vie. Il peut affecter vivre nous, il peut affecter canaux nous et il peut affecter machine nous. Aussi il peut affecter placement pêcheur.
Assurer c'est pour ça difficile pour pêcher ça assurer quand d'autres après la meilleure et puis pour adopter changement du climat.
Climate change is happening. Are you prepared? Changement climat qu'a fait. Est-ce ou préparé?
Suicidal thoughts, like other mental health challenges, can affect anyone. It can be you, your colleague, family member, or neighbor. Everyone has a role to play in preventing suicide. Know the warning signs. If you or someone you know is in crisis or emotional distress, call the suicide hotline at 203. Remember, help is available. This is a message from the Employee Assistance Program, Department of the Public Service. Contact us at 468-2269 or 468-2260.
Somebody coming?
I'm trying to say somebody.
That's good. Is it?
That's fine.
Welcome back to Nationbeat. I am Claudia Monlouis, and we are discussing miscarriages of justice in the Caribbean. Are they real or largely imagined? And I would like to welcome Attorney at Law, Mr. Alberton Richilo, to join us.
Thank you.
And just before the break, I posed the question, what would be some of the systemic gaps that lend to or contribute to inadvertently a miscarriage of justice?
Who would like to start?
Well, I'll start.
Go ahead. Stop.
Well, I suspect inadvertently it may very well be a question of a delay in hearing cases. As a matter of fact, whilst I was sitting out there and I was listening, for instance, you have a 3-year-old, but that may be a little too. Let us say, for instance, a 7-year-old who had an unfortunate sexual experience. And then you have a case which lasts for about 14 years. What can that person tell you about the recounting the events which took place 14 years ago? And of course, it cuts away at a significant part of what justice requires, primarily because you're cutting away half of the truth. Although I'm a defense lawyer, I have always advocated that it is important that a lot of cases be heard as soon as possible. Let me give an example of what I'm speaking about. In the Eastern Caribbean, for instance, the last case that I knew that was where proceedings were stayed for delay in St. Lucia, that person was on remand for 15 years. For one. There are other cases which have come, and of course we have argued for delay after 10, 11 years. They say, no. And of course, there is a new system which has been implemented, legislative and otherwise, in Canada. And I know one in particular where they're saying, after 3, 4, 5 years, the cases should be completed. There's one case in Dominica in which a judge bypassed, I could say jurisprudentially, bypassed the whole idea of the 5, 7 years and said, well, let us try and see if we can implement the system which has been put in place in Canada. And of course, stayed the proceedings after 7 years. And you know what has happened? That particular judgment, no one is now looking at that particular judgment. And it is because of a culture of either one, laziness, being lackadaisical, not putting in place the financial resources which would be required to hear cases as expeditiously as possible. And so what happens? Over time, it may not be a child, it may be, say, for instance, a murder case or any other kind of case. You have witnesses dying. So you have to rely on witness statements of persons who you cannot cross-examine. So therefore, all of these things are likely to create a serious miscarriage of justice, because justice is not only for the defendant, as far as I'm concerned, it is also for the victim. Because at the end of the day, even if I'm a defense lawyer, I don't know where I'll end up, I may very well be a victim too. You understand?
Absolutely.
So we have to look at the thing
Possible.
from a realistic point of view. I have seen cases, for instance, like only recently in the Privy Council, sometime last year before last, where a man remained on remand in prison for 18 years. Until, of course, he got the opportunity, the resources most probably was available to him, or I think that the Death Penalty Project, which is a sort of gratuitous kind of organization, and he was able to, and after 18 years, it was found that this man was innocent because of a number of flaws in the system. And vice versa. You'd find sometimes, and as I was indicating, that the guilty man would very well go free because of these kind of systematic failures. And so it is important, in my view, that it is time we develop a culture of understanding that things have to be done, and it has to be done now. Another thing which I would look at, and I have been considering, is why is it that we don't, and which is one of the most prevalent offenses, sexual offenses. I find it very difficult why we have not had a sexual offenses court. A sexual offenses court which would remove everybody from the whole circus of the murder, etc., and find ourselves in. So these are the things which are, in my view, more particularly a delay. Delay has been, and I've heard, time and again cries about delay, etc. And I ask myself every day, why is it that we have not seen it necessary to follow that decision in Dominica? Because you know why? Everybody wants to sit back. Everybody wants to sit back. Well, when you see you call for the file, oh, well, the file is not ready yet, I mean, up to this morning, I had a matter in which this man was arrested from the 24th of May last year. And up to now, the case can't even get to the point of sufficiency hearing in the High Court. So the question is why? Is it that it is not sufficiently, I know that my head will be taken off for it, but I'll still say, I do not know if it is because it's not sufficiently judicially officer driven. You don't get everybody on their toes. I mean, what is happening? Why is this thing down here for so long? So we need that kind of culture. And unless we change that culture, I cannot see anything happening. The injustice, as far as I'm concerned, the miscarriage of justice will still be there.
I very much like what Mr. Richlow is talking about. And as he was talking, it occurred to me that if you were a 7-year-old child, male or female, who was sexually assaulted, and that case took 14 years and you're now 21, part of justice is also resolution for the victim.
Exactly.
Can you imagine you as a child having to live 14 years, go through your adolescence, go to your early adulthood with that trauma of having been raped when you were 7 years old? What has happened to that mind? What's the quality of life of that person going forward? And I mean, so it's not just a matter of, it took a long time. No, it's about justice for that person. The other area that I think is where I see problems is coroner's inquests. Now, I have seen many deaths. Now, a coroner's inquest would happen in a variety of situations, but very often in a death where the DPP or the police are not 100% sure whether they should charge somebody, was this really anything, and they want to ventilate in a court, but it's an inquest to find out exactly what transpired to cause his death. It happens a lot with hospital deaths, in particular. When sometimes these inquests might take 5 years, 6 years, or sometimes never.
Never.
And that is a miscarriage, because I've always felt one of the most important things about an inquest is to cause a system to change. If a hospital, for instance, has systems that are breaching and causing problems with people, the inquest must come up with that and force the hospital to fix some of these problems, because other people get hurt. So inquests are so important in my view, but they're not given any priority. And I want to endorse what Mr. Richlow is saying, the culture. Our culture of accepting delays in justice and inquiries and resolutions is, I think, not acceptable. And if we want to be a powerful people and a properly developing nation, it's time we address justice. Justice is probably one of the most important attributes of development. And don't be surprised, a lot of the violence that we see in our land is because people perceive injustice.
That is true.
You know. And whereas if you could get the matters resolved, you'd get a lot more faith in the police, a lot more faith in the system, and therefore much better behavior from the population. So this miscarriage of justice is not just a theoretical thing for some people, it affects every single one of us.
Since we are talking about timing as well, how does that impinge on DNA? Because we hear oftentimes, and of course everybody could weigh in, Mr. Richilo, beginning with you, how can issues such as contaminated or compromised DNA evidence contribute to miscarriages of justice?
Oh, oh boy. Let me deal with it from the back and then go on. First of all, and I noticed, in fact, when I was at law school, we had a subject called forensic, was it forensic evidence? Or medical legal evidence or something like that. But anyway, it was for us to have studied or at least know about something about medicine, whether it be post-mortem examinations, lacerations, incised wounds, whatever they were. So at least we would have known about these things. But I think that now we are moving into a developing world. And you know, one of the things I would have liked to have seen, and even if you say I can do it now, at my old age, in any event, is to be able to understand the science of DNA. It's important, in my view. And you know what it's like, for instance, if you have, I mean, with Dr. King as a pathologist, okay, you'll hear him tell you, give you certain terms, medical terms, but sometimes you're sitting there as defense lawyer and prosecuting lawyer and judge, and the DNA expert is giving evidence. You don't have the slightest idea of what they're speaking about, you know. You swear to God that you're in Moscow. You understand? Yes. No, seriously. And in fact, it has shown up its face in a number of cases over time. Because first of all, DNA is fairly recent. It's fairly a novel aspect of the development of the science. And it is amazing. It's amazing. I recall doing a matter and where I did a lot of reading on it. And what was in issue was what is called the low template DNA aspect of. And only for me to find out when I did the reading that in 2007, a judge in the Supreme Court of Ireland, it was the time of the Omagh killings and bombings, etc., actually found that the LTNA DNA testing was not up to standard. Yep. So it had to be suspended for about 6 months. I think thereafter they came with it and so on. But then he made certain comments in that judgment which suggested that there must be, and you have to ensure that there is no contamination, etc. And he thought that it would have been an injustice to have convicted him. Then it is even far more startling that in 2024, you had a case coming out of Bermuda and Julian Washington, in which it was found not at trial, not at the Court of Appeal level, but at the Privy Council level, where there's fresh evidence which the lawyers for the appellants employed, and to discover that there were fundamental flaws in the testing and interpretation of the DNA results from some lab in Florida. I think right now it's defunct.
Yes.
Trinity Labs. And so you see, my view is that I think it is time that prosecutors, judges, and even defense lawyers like myself get a hand into understanding. It is important. Because if you have if you have an expert who is giving evidence, the judge is supposed to direct the jury properly on the evidence which is given, and the judge, him or herself, does not understand what directions to give. Where do we go? Yeah. In Bermuda, what the scientists, the evidence said that the man, it was a partial profile, which was found on bullets, etc., etc. And the analyst said, I think there's a random ratio of 1 in 46 million.
Yes. That he was not.
That he was not.
The,
now.
The way they stated
now,
that. Yep.
How many people are in Bermuda? So it is a question, and I think they said that they did not have the necessary facilities to have tested for certain aspects. So my view is that it has to involve an understanding. So, and it has to be put according to what Stephen was saying, Dr. King was saying there this morning. We have to be a little far more humble. We have to understand. We do not want to. We should not place ourselves in a position to think that we know it all, and so therefore I can never be corrected. Because whatever is involved, whether it is DNA, whether it is even a judgment, it is really the opinion of a person. And it does not necessarily mean that your opinion is right. Sometimes the only reason why your opinion is right is because it's final. You understand? So
just that little bit of information.
You understand? So from my perspective, I think that there should be education. Luckily for me, yesterday, I was in a particular scenario, and I was assured and comforted that the director of the lab said, well, now defense lawyers can have access to the lab, so at least they'll be able to understand and interpret. And that is important. For me, as far as I'm concerned, when I deal with these situations, I do not look at it as from a lawyer's perspective, either a win or lose case. Because we must understand that at the end of the day, people are affected. We are human beings. The defendant is a human being. The victim is a human being. And so therefore, we have to look at it from that perspective. But sometimes we'll come out down here, well, I am the forensic scientist. I have a degree, a PhD, and so on and so forth. And sometimes the people are talking a lot of rubbish and we don't even know.
And it's true.
No, but it's true.
It is true.
Yeah.
It is.
I very much like what Mr. Richard said about the justice is how important it is, and how, because in my own practice, when I was involved, I was very happy to speak to defense attorneys as well as to prosecutors on the evidence that I'm giving, because my evidence does not change depending on who I'm speaking to.
Amen.
My evidence is my evidence. Now, the interpretation of it, I'm very happy to have conversations with everybody on the interpretation of this evidence and how I think it can or cannot be interpreted. Because the court, although it appears adversarial, it is adversarial, prosecution, defense. And it's set up that way so that the two best scenarios are put forward, adversarials for and against. And then there's a judgment that is arrived at. But the for and against is not, it is actually there just to allow the court to get to justice. And both sides need to understand that. So if the prosecution knows things that say that this is not the person who should be charged, I think the onus is on the prosecution to say, full disclosure, sorry, mistake here.
Yeah.
And similarly, I mean, it may be harder, but similarly for the defense, if you know something, then maybe it's time to have a conversation and say, hey, look, let us come to an arrangement here. And to allow justice to happen. Now that's a more difficult scenario, I appreciate, but it's something for people to think about.
I think the points brought up are so relevant, and there's so much. I was listening to both of you, and there's so much to discuss. So Mr. Richilo brought up the point of education, and I think that I totally agree with him. Education is important, and because we are giving a jury and a judge information for them to make a decision. But if they cannot if they cannot understand what we're saying, or even relate to what we're saying, then it doesn't help the scenario. lawyers like Mr. Richelieu and prosecutors have to be able to question what any professional is doing. And if they don't understand what we do, they cannot ask the right questions. They cannot pinpoint, hey, did you think of this? And for us as professionals to say, you know, maybe I did not consider this. Maybe I need to go back and look at what was done. And Mr. Richelieu, I can assure you that the lab has always had the stance of, we are a neutral party. We are not looking at things from a prosecutor's point of view or the defense's point of view, because we stand for justice. We stand for the cause of justice, which means we have to be as unbiased and objective as possible. So we literally are telling the story. We are the voice of the evidence. That's how I see it. And so if the evidence points me this way, all I can say is what the evidence says. And I do not have a stance as to, well, and that comes into play. Bias comes into play, and it's something that as scientists we are also aware of, and why we do not take in certain information. So we do not read all of the witness statements, because that can bias you, right? So we consider all of those things. Another thing that you brought up, and I think about it all the time, is that I feel like we're building the house and we're trying to live in it. So I think that's what's happening. So a lot of the cases, so for more developed countries like the US and the UK, you have a system that has been established. And to bring in Dr. King's point, you have inquests and you have inquiries when something doesn't seem right. And you have these huge reports coming out of them. Just recently, the Queensland in Australia had this huge scandal, and there was a inquiry into their DNA, the way their DNAs, their procedures were conducted. And they brought up quite a few recommendations. But with us in the Caribbean, we are still setting up the system. We're setting the system in a very fragmented way. And also, like you said, we are not willing, the culture is not there to interrogate the system. And that is what's important, so that the system can now tell you, hey, this isn't working well, and this is why it isn't working well, so that we can fix it. But like you said, the culture isn't there. And that is why I strongly advocate for quality. And one of the reasons why the 9th Medical Legal Symposium is so important, and why over the last 9 years it's been something that has been ongoing, where you spoke about training and understanding. That is where individuals can come in. Individuals from civil society, lawyers like yourself, pathologists, students can come in and really understand the different disciplines. And so symposiums like this one, I think this one it's really interesting. Let me just let the public know of some of the things that are coming up. Some of the things in the program. We have things like factors that influence the disclosure of sexual abuse in minors, based on what you just spoke of in terms of courtroom experience. For the last, say, 5 years, I believe, the laboratory has been conducting an exercise where we do a moot court with our scientists and with prosecutors and defense attorneys. So
I've never been invited.
Now you see what's funny, 7 years, it's the last 7 years. What's funny is that, I think we had this discussion, I have this discussion all the time with my director. We send out invites to the Bar Association. We send out invites to everybody, and we usually do not get many people coming. And that is disheartening for us.
As a matter of fact, I gave the answer to the director secretly whilst I was sitting there.
That's why. Okay.
Not for public consumption.
That's fine. We will use that information to make sure that they come. But the symposium has an aspect of an interactive practical courtroom training exercise, where a police officer, so there's a scenario, a police officer, a medical doctor, and a DNA analyst will be put through the rigor. Prosecutors questioning and then cross-examination, so that we can show best practice. We can also inform and have the participants interrogate and ask questions and understand, how things should be done.
Can you give us an idea of who will be there, or who can also attend?
We are open to the public, in terms of people who are interested in this subject. So lawyers, prosecutors, students who are interested in pathology, in science in general, social workers, judges, magistrates, defense lawyers are all welcome. And I think it is important, like Mr. Richard said, to understand that sometimes what I know as a DNA analyst is affected by what a police officer is doing. And I remember, and the media too. By the way, to bring in the media, I don't think we spoke about that. We've been speaking about all of the disciplines. I think that the media has to understand that they are the mother guardians. So they're supposed to be asking the hard questions. And I find in St. Lucia, I can speak for St. Lucia, I don't think we do that very well. I think something happens and people might not like me saying this, but something happens and it's just like, oh, okay. The media and journalists are supposed to be questioning us and saying, but how is it that this happened? And that is how these inquests can come about. How we can get these reports and recommendations to improve the system. Because like you said, it is not about whether we have these great qualifications and we're doing all of this great work, but if we cannot improve on the work, how does that help us? Right? And I think the media has a huge part to play in that.
And the other thing the media has to be careful of is people are innocent until proven guilty. Our media and our public have a bad habit, in my view. It's part of the culture that as soon as somebody gets charged, automatically guilty. Guys, I do that, guys. I know, you know. Yes. So we need to be so careful. And I think
there's social media.
There's social media too, but even
social media police.
But even the general media, people like yourselves, can also help this culture by reminding people and asking the right questions about, is this person getting a fair trial in this little country of ours, you know?
And we have to be very lucky because everybody knows everybody else.
That is difficult.
That is the problem.
So reputation, miscarriage of justice, if you want to talk about that, somebody gets charged of a rape, the man or the woman is found not guilty, but that reputation is damaged for life. Yeah. Because everybody saying, I said, the court just said find me guilty, guys. I made guilty.
Yeah.
And they will find anything to pinpoint on this person. They'll be like, oh, yeah, and I saw them doing and they're not recognizing. So even when Mr. Richardo spoke about the person on remand for 18 years, imagine this man is found innocent.
That's right.
And then he goes out, how does he
readapt
to society? Because now everybody said, oh, mate did that, mate, yes,
it's just that they find
him guilty. How does this person come back into It is a very sad situation, and I think that is indeed a miscarriage of justice.
But as a matter of fact, I just want to make a point in relation to the miscarriage of justice to see how serious this thing is.
Very quickly, as concisely as you can.
The Bermuda matter I spoke about, as a result of that, it has cost the government a lot of money to review over 500 cases where persons either were convicted or have been charged with that kind of situation. I would just like to point that out.
So I'll take this as your final comment, and I would invite in 1 minute a closing comment from Dr. King to be followed by Mrs. Quinlan.
Oh, well, simply, I think it's important that the general public understands that there are miscarriages of justice, and that indeed, and we advocate, as a population, we advocate with the government and those in charge of resources to put all the resources that need to be put in place to develop a proper system of justice, investigation, etc. We must invest now. We must deal with the problems. I want to see in the next budget a significant budget to deal with the matters of investigation and justice.
All right, so I will use my minute to encourage persons to come to and to attend the 9th Annual Caribbean Medical, Legal and Forensic Symposium, because as you have heard, it is a place where you can learn quite a bit within your respective fields, and also to understand what the other fields are doing so that it can impact you and to help you do your work in the best way possible.
Thank you very much to all of you, our guests today. This has been a very engaging edition of Nationbeat. I am Claudia Monley, saying goodbye.
The panel, the discussion, an objective and impartial view of the issues of interest to you. Nationbeat is on now.